And good afternoon. I'm attorney Michael Bender with Gray Legal Group. Welcome to this week's edition of Ask a Lawyer. Before we start, the information in this video is for general purposes only. Nothing should be taken as legal advice for any individual case or situation. The information is not intended to create, and receipt of viewing does not constitute an attorney-client relationship. Flying solo today, so we're going to go ahead and ask a few questions, answer a few questions here, best I can without my partner, attorney Allison Tilton, who is unfortunately under the weather today. Talking about some finances today. We've got some questions with regards to separating finances as well as how to reduce support obligations. First question we've got here today is, when can we separate our finances? My soon-to-be ex-wife and I are still sharing our finances, but we are separated and filed for divorce. She spends a lot of money on stuff that isn't for the house or our children. I told her I was going to set up my own bank account and I would give her a set amount of money each month. She got upset with this and threatened to take me to court. I know there's a 6-month waiting period in California, but when am I allowed to separate our money? I want to start with the last part of that question first with regards to that misnomer of a 6-month waiting period. There really isn't a 6-month waiting period in California. Once you and your spouse have separated, that's going to end essentially the marriage, or when your community property it ends. The 6 months is actually a time that can be found in the family code, but that's the earliest that you can actually be divorced or your marital status can terminate. Has nothing to do with support, nothing to do with property division at all. It's just one of those, quite frankly, archaic laws that have stuck around, keeping parties together at least for 6 months after a divorce is filed. But talking about splitting up the finances, once you and your spouse separate, you can start setting up your own finances. Any money that you're earning after date of separation is yours and yours alone. It is your separate property income. You can go ahead and set up your own bank account, put your own income into that account, and use it however you please until there's a support order in place. Now, the person who asked this question says he's going to go ahead and give a set amount of money each month. What I'd recommend to this person is contact an attorney, figure out not exactly, but what ballpark of what your support calculation is going to be. Mentions children, mentions the house, and so forth. So there's going to be potentially a spousal support award and a child support award as well. Start paying that amount, because if as she threatens here, goes to court to get a support order, she has every right to go ahead and do that. If the court makes orders for child and spousal support, they can actually make it retroactive to the date that she filed. But any money that you've paid during that period of time is actually going to go towards that order and count towards that order. Second question here goes to the calculation of spousal support. Can a vocational analysis be used to avoid paying spousal support? My husband is asking the court to give him spousal support. He has had the same job for the past 15 years, but only works for a small amount of money per hour. He has a bachelor's degree and could earn a lot more. Can he be made to take a vocational evaluation so I don't have to pay him spousal support? Now, first off, completely avoiding spousal support, there's a lot of questions that go into that. Probably not. It just depends upon how long of a marriage here. I don't know if 15 years of marriage, doing the job, if that's coinciding, whatever. But as far as using the vocational evaluation, the purpose of the vocational evaluation is actually to establish what the earning capacity of that spouse is. Here in this situation, they may have a bachelor's degree. They can go ahead and take the vocational evaluation, but you kind of got to think about this. When was that bachelor's degree given? Not all that much information here, but the skills that they've used in employment have been the same for the past 15 years. Doesn't sound like there's been any growth. Now, also on the one argument that can be used here, when we're looking at spousal support, if you've been married for that entire time of 15 years, why all of a sudden now should they go out and get a better job just because you're deciding to go ahead and divorce. There is a fiduciary duty in a divorce situation of the higher income earning spouse, if it's been that way during the marriage, to provide spousal support. But yes, a vocational evaluation can be used. We see it quite often, and that's going to address what the ability of the requesting spouse, what their ability is to earn. But it's also going to show what opportunities are out there. And really, there's a two-pronged test when we look at what income is used for the purposes of support, ability and opportunity. So yes, you can go ahead and use a vocational evaluation, but before you spend the couple of $1,000s to go ahead and have your spouse go through that, contact an attorney, go through all the spousal support factors, see if there's going to be a benefit of going through that vocational evaluation. So. Well, that's it for this week. Thank you for joining us on Ask a Lawyer. Join us every week as we discuss family law issues important to our community. If you have a legal question or a topic you'd like us to address, go to thegreatlegalgroup.com and click on Ask a Lawyer. We'll see you next week and every Tuesday at 1:30.